Good afternoon. I think people are being logged in now. Right. Good afternoon. I think most of our participants have joined us. Oh, still a few more coming in. Okay, let's kick off. I'm Jamie Presland. With me today, Liam Evans. We're going to give you our Wednesday webinar today, Housing Law for Family Lawyers. We are going to cover, first of all, legal framework, what is in the Housing Act 1996, relevant case law, powers of the family court when housing issues arise, and a look at some of the duties of local authorities which are there inside the Children Act. There's an opportunity for questions and answers, which we'll try and deal with at the end. At the foot of the page, you should see a little button called Q&A. If you type in there, we'll try and deal with it in the time at the end of the webinar. So now over to Liam, who's going to take you through the legal framework of the Housing Act of 1996.
Hi everyone. I'm going to start the webinar this evening by talking a little bit about the relevant legal framework under the Housing Act 1996. This slide just lists the relevant statutory provisions, that being Part 6 and Part 7 of the Housing Act, and the supplementary regulations made under that Act also. You'll also see listed on the slide there some relevant statutory guidance. The statutory guidance is a really good resource and is very accessible for those of you who are keen to learn or keen to get into this area, and maybe aren't comfortable going straight to the legislation. It provides a lot of thorough, detailed guidance, and I would recommend the guidance listed as a starting point for anyone unfamiliar with the area. So turning to Part 7 of the Housing Act, this is the section that deals with homelessness. Section 175 of the Act includes the definition of what it means to be homeless. In essence, it means a person is homeless if there is not accommodation that it's reasonable for them to continue to occupy. Section 176 of the Act specifically provides that it's only reasonable for a person to continue to occupy accommodation if it's available for occupation by any other person who normally resides with them as a member of their household, or any other person who might reasonably be expected to reside with them. So that would include, for example, dependent children. As family practitioners, I know a lot of us work with victims of domestic violence as well, and I just wanted to highlight that Section 177 of the Act also specifically states that it's not reasonable for a person to continue to occupy accommodation if it's probable that this will lead to the risk of violence or domestic abuse against them. So what that means in essence is that, generally speaking, victims of domestic violence are homeless for the purposes of Part 7. Part 7 of the Act is quite long, and essentially, in essence, how it works is that it imposes duties on local authorities, and those duties are listed on the slide there. Different conditions apply to those duties and different timings also. I'm going to focus on the main two, or the really important two. That first is the duty to provide interim accommodation in Section 118 of the Act. That requires a local authority to make accommodation available to a person if they are satisfied that that person is 1, homeless, 2, eligible for assistance, 3, has a priority need. The concept of priority need is one that is used again when determining whether the local authority owes the main housing duty, and that term is defined in Section 189. It essentially includes a list of people who are defined to be in priority need for the purposes of the Act. That includes, for example, pregnant women, a person with whom dependent children reside or might reasonably be expected to reside, a person vulnerable because of old age or mental illness or physical disability, and a person who is homeless as a result of domestic violence. The interim accommodation duty is important because essentially, if the conditions are satisfied, the local authority is required to provide accommodation pending its other assessments and pending a determination whether the main housing duty is owed to an applicant. Moving on to the main housing duty, that's set out in section 1932 of the Act, and it applies where a person is, again, 1, homeless, 2, eligible for assistance, 3, didn't become homeless intentionally, and 4, has priority need. So you'll see that the conditions are very similar to those for interim accommodation, except there's the added limb of not being homeless intentionally. If a person is owed the main housing duty, and that's really the golden ticket that the applicants want to be owed by local authorities, the local authority has to secure that accommodation is available for the applicant, and that duty comes to an end in various circumstances, mainly if the person's offered housing pursuant to Part 6, which I'll move on to discuss in the next slide, or if a private sector offer of accommodation is made. It's also good to be aware that that duty can end, for example, if the person refuses an offer of suitable accommodation. The last thing I'm going to say about Part 7 before moving on to Part 6 is to flag the right to request a review of decisions made under Part 7. Section 202 is the right to internal review, so that's a request to review certain decisions made by the local authority that will be done by a review officer within the same authority. The time limit for requesting one of those is 21 days. And then, if a person is dissatisfied with the outcome of that review, there's a statutory right to appeal to the county court on a point of law pursuant to Section 204. It's quite complex, and there's some quite complex case law and guidance on when a person should use Section 204 as opposed to a judicial review. And it would be my recommendation, if you are working with a client who has a housing decision made that they want to challenge in the court, at that point, it's worth seeking legal advice to ensure that the client is pursuing the right route of challenge. Moving on to Part 6 of the Housing Act. This is the part that applies to allocations of social housing. Section 166A of the Act sets out a requirement for local housing authorities to have an allocation scheme. And the purpose of that allocation scheme is to determine priorities and to set out a procedure to be followed in allocating housing stock. Section 166A14 expressly provides that a local authority must not allocate social housing other than accordance with the allocation scheme. This ties in with the concept of reasonable preferences, which is on the slide. Section 166A3 of the Act sets out that an allocation scheme must be framed so as to secure that reasonable preference is given to various groups of individuals listed in the statute. That includes people who are homeless, people occupying insanitary or overcrowded housing, people who need to move on medical or welfare grounds, and that includes grounds relating to disability, and various other individuals. You'll see there that under the heading Allocations and Domestic Violence, there's some statutory guidance mentioned there. That statutory guidance also encourages local authorities to give priority to victims of domestic violence, and expressly states that that can be done under the limb of medical or welfare grounds. I'm not going to dwell too much on that second section, but I would say that the guidance on improving access to social housing for victims of domestic abuse is a really useful tool, not only in relation to allocations, but also in relation to Part 7. And it provides really useful guidance where, for example, a victim of domestic violence is being housed in a refuge. And it sets out some options for local authorities if, for example, a victim of domestic violence wants to move back into the family home, provided it's safe to do so. The last thing I'm going to mention about Part 6 is that there is, again, as with Part 7, a right to request a review of certain decisions. That right of review is set out in Section 166A9, and it provides that a person can request a review of, for example, a decision by a local authority as to whether they are eligible for assistance in the first place, and also how their case was assessed in considering whether to allocate accommodation. The scope for challenge under Part 6 is more limited than scope for challenge under Part 7, and generally the route is judicial review. So if your client is dissatisfied with a Part 6 allocation, again, it's something I would recommend they seek specialist legal advice on. The next thing I'm going to cover is to move on to discuss some case law examples that are relevant to us as family practitioners, in which the scheme in the Housing Act has been applied. The first case I'm going to discuss is Holmes Moor House and London Borough of Richmond upon Thames. That's a decision of the House of Lords. Essentially, it was a case where the parties had previously agreed a shared residence order in relation to their 3 children. The father then presented to the local authority as homeless and applied for assistance under Part 7. The local authority accepted that the father was homeless, but not that he was in priority need. The father then challenged that decision on the basis that he was in priority need because he was a person with whom his children, could reasonably expect to reside, and he relied on the shared residence order made by the family court. In paragraph 21 of his leading judgment, Lord Hoffman said, "I think it will only be in exceptional circumstances that it would be reasonable to expect a child who has a home with one parent to be provided under Part 7 with another so that he can reside with the other parent as well." So essentially what Lord Hoffman's saying there is where you have 2 parents who have separated and both want the children to live with them, they're not necessarily going to be allocated accommodation. Both of them will not necessarily be allocated accommodation with enough bedrooms for all of the children. One exception discussed by Lord Hoffman is, however, where one of the children is suffering from disability or a parent is suffering from disability, and that makes it imperative for the care of the child to be shared between the separate parents. I'll move on to talk about how that was applied in El Ghurair in a bit. One of the useful paragraphs for family practitioners, in my opinion, is paragraph 17, and that was a recognition by Lord Hoffman that actually, in a case where both parents don't have adequate accommodation, the court should not have approved a shared residence order in the first place. This was again something that was mirrored by Baroness Hale in her concurrent judgment at 37. So it's a useful authority in a case where you're representing a client who is resisting a shared residence order, and especially if the other party is having accommodation issues. Moving on to talk about El Ghurair and the Royal Borough of Kensington and Chelsea. This was a case that was very similar fact pattern to Holmes Moor House. There was a homeless father and his 2 children lived with their mother. The father argued that he was in priority need for accommodation because the children could reasonably be expected to reside with him. The mother had disabilities. Those disabilities included disc degeneration of the spine, stabbing attacks in her back, agonizing pain, knee stiffness, and panic attacks. The local authority held that the father was not in priority need, and this was upheld by the Court of Appeal. The Court of Appeal essentially said the children already have a home, and there's no reason for them to be provided with another so that the father could care for them. One thing that the Court of Appeal did consider in this case was the relationship between the parents, and a finding, and they approved essentially a finding of the local authority that the relationship between the mother and father hadn't deteriorated so much that the father couldn't go to the mother's home to provide assistance caring for the children. Now, of course, there'll be lots of cases that many of us work on where it would be wholly inappropriate for that situation to persist in the father, or the mother can't be in the other's property. And so that might be one area for distinction to think about if you get a similar fact pattern arising in one of your cases. The last case I'm going to discuss is Bull and Oxford City Council. This was a case where the 3 children lived with their mother in the former matrimonial home, and the father had been accommodated by the local authority in a 1-bedroom property. There were various problems at the mother's house, including the children alleging that the mother was drinking excessively and left the eldest children to care for the younger children. So the children said to their father they wanted to move in with him, which they then did. The father's landlord then provided him with a notice to quit to end his license on the basis that the property had become overcrowded when his children moved in. The father was then moved into interim accommodation with the children, but the children still regularly stayed with the mother at this point. The local authority decided that the children did not reside with the father and were not in priority need, and also that he'd become homeless intentionally and therefore wasn't owed the main housing duty. In the Court of Appeal, Lord Justice Peter Jackson found that the children did reside with the father in the temporary accommodation. However, he did approve the finding of the local authority that the father had become homeless intentionally and on that basis wasn't owed the main housing duty. I flagged this case because I think it's useful to be aware that there are circumstances when maybe in the heat of the moment when one parent says, oh, the child wants to come and live with me, and that decision is made, it could have knock-on consequences for your client's housing situation, especially if it leads to the property becoming overcrowded and the landlord then decides to evict. The last thing I'm going to discuss before I hand over to Jamie is the powers of the family court in cases where housing issues do arise. I'm sure many of you who work in care proceedings have probably had a case where those proceedings have been delayed for quite a significant period because of housing issues of any of the parties involved. One such case was in the matter of aged children, which was a decision of Sir James Mumby when he was president of the Family Division. This was a case where care proceedings had started on the 27th of May 2016. It was a non-accidental injury case and there had been concurrent criminal proceedings. But by the beginning of 2018, the focus of the proceedings had been how was the mother going to be rehoused with the two children. Suitable accommodation was only found by the local authority in May 2018, and there was still work that needed to be done before the family could move in. In the course of his judgment, Sir James gave some guidance on what the courts can and can't do in relation to third-party agencies, and I'm going to focus on this talk on housing authorities. I'll start with the things that the family court can't do. The first is that the housing authority, the family court can't tell the housing authority how to exercise its powers. So the family court can't say, for example, that the local authority needs to allocate X social housing or a property with Y amount of bedrooms to the family. That's also a point that was made by Lord Hoffman in Holmes Moor House. The next thing the family court can't do is direct that resources be made available by the local authority. That principle has been long established since the 1980s in the case of Ian Liverpool City Council. Sir James did say, however, that even though the family court can't pressure a local authority how to use its resources, and a housing authority how to use its resources, it can seek to persuade. Of course, the line between those two things is quite blurred, and a lot of that will depend on how interventionist a judge you are in front of, how willing and how far they're willing to go in those cases. The last thing that the court shouldn't do is add the housing authority as an intervener. The reasoning behind this is that it suggests that the housing authority is accountable and has to justify its decisions to the family court, which is not the case. Moving on to the things that the courts can do in these cases, the court can clearly request full and the most up-to-date information on the housing situation. That power is given by Section 31G of the Matrimonial and Family Proceedings Act 1984. Sir James, in this case, also noted that the parties should consider at an early stage how any third-party agency should be engaged. So it might be the case that early on in proceedings, for example, you seek an order for disclosure from the local housing authority if it looks like housing is going to be an issue. The next thing that the family court can do is require the decision maker to give evidence or provide a witness statement. In this case, there have been quite detailed directions made to the housing authority to provide a schedule in a tabular format setting out how explicitly the timeline for works to the property will be done and when it will be ready for the family to move into. Again, that can be quite a useful direction to get because it sort of keeps the local authority and the housing authority accountable, and it gives some clear timelines for the court to see, which it will think about when considering any care plans. The other thing is that the court can, as I've said, provide order witness statements. One thing I would say is that in some cases it might not be satisfactory just to get a witness statement from a housing officer. It might be better to seek an order that a witness statement is given by someone sufficiently senior to actually implement the changes. It might be if the housing authority is acting particularly egregiously in a case, it might be possible to persuade the judge to even ask the head of housing to attend and account for any failings that are delaying family proceedings further. And the last thing that Sir James clearly said the family courts can do in these cases is to explore and probe the local authority thinking. Ultimately, it's the job for the family court to approve any care plan put forward by the local authority, and in doing that, they have to consider the options put forward by the local authority, and in that they can ask the housing authority to explain why it's come to the decision that it has. That's what I wanted to say. So I'm now going to pass on to Jamie, who will talk about housing duties of local authorities under the Children Act 1989.
Thank you, Liam. Now, just a reminder, there is a question and answer box. If you want to type in any questions, we'll try and deal with them at the end. As we kicked off a few minutes late, we'll probably carry on to about 5:15, unless Liam shakes his head. No. Okay. Right. Now, looking at social services duties which arise actually under the Children Act. First of all, in relation to 16 and 17-year-olds, and then families with no recourse to public funds. 16 and 17-year-olds, if a 16 or 17-year-old presents as homeless, there are three ways that they can be provided with accommodation. They can become a looked after child under Section 20 of the Children Act. That means the local authority becomes a child's corporate parent. Looked after children are automatically entitled to support, including funding for educational courses and priority access to certain types of accommodation, which must be regulated. They can be accommodated as a child in need under Section 17 of the Children Act. Children in need are not entitled to any of this support, but there can be a discretion to provide it, or they can be accommodated under the Housing Act 1996 Part 7. Which is the right way? Well, next slide. Looked after children, the statutory guidance is clear that in most cases a local authority should accommodate a child as a looked after child. And there are only two reasons not to do this. Firstly, because the child is not a child in need under Section 17. Child in need will be familiar to most family lawyers. Under Section 1710 of the Children Act, the child is to be taken to be in need if they are unlikely to achieve or maintain or have the opportunity of achieving or maintaining a reasonable standard of health or development without the provision for him of services by a local authority under this part. Or health or development is likely to be significantly impaired or further impaired without the provision for him of such services, or he is disabled. This is a filter that means, for example, a young person might fall out with mum and dad and turn up at children's services and say, I want to be accommodated. But it needs to be more than just a simple falling out. It needs to be something with enough long-term consequences to qualify under Section 1710. Ofsted research, however, on how local authorities support homeless children, published just a couple of months ago, shows only 40% of homeless 16 and 17-year-olds are accommodated as looked after children. The link to that will be in the slides when we send them out to you. Next slide, please, Liam. A case called TG and Lambeth illustrated the significant difference, which is entitlement to leaving care support. Once a young person has been looked after for more than 13 weeks, ending after their 16th birthday, they become a relevant child. A former relevant child is entitled to leaving care support, which is to provide the assistance that a reasonable parent would, until typically they are 25. Back in 2011, the duty continued until the 21st birthday. Lord Justice Wilson in TG and Lambeth, where a local authority had purported to house somebody under the Housing Act, despite having made an assessment that they were a child in need and eligible for support under Section 20. Counsel for the local authority asked the question, should we, Lord Wilson LG, is Wilson LJ? Lord Justice, sorry about that, we'll correct that. Should we, as counsel for the local authority, conclude that, if asked, the appellant would have expressed the wish to be accommodated under Section 20 of the Act of 1989 rather than under Section 188 of the Act of 1996? Even had he not expressed such a wish, his views might not have prevailed if his welfare had demanded otherwise. But my main answer to his second question is, again, yes. That's a local authority council's question. A proper respect for the appellant's appreciation of self-interest yields a conclusion that, had the difference been properly explained to him, the prospective financial and other benefits available to him, at least until his 21st birthday, in the event of accommodation. Sorry, I can't. In the event of accommodation under Section 20, would have secured his request for it. Bear in mind, leaving care support now carries on to 25. Young people told they get nothing or they get leaving care support until they're 25. We'll vote for the latter. Next slide, bed and breakfast. Bed and breakfast accommodation is not suitable for 16 or 17-year-olds. This is taken from guidance, the link to which is on the following slide. You'll see 5.10, children and housing services are reminded that bed and breakfast accommodation, including hotels and nightly let accommodation with shared facilities, is not considered suitable for any 16 or 17-year-old. Examples of accommodation for use in emergencies include night stop type or short-term supported lodgings in the homes of trained and vetted hosts, emergency beds in specialist young people supported accommodation services, other specifically designed crash pad services with on-site support, and for looked after children, emergency foster placements. More detail on that slide and on the following slide, if you can go on to that. For example, as to partners of 16 and 17-year-olds, by the age of 16 or 17, many young people are forming relationships, a few may themselves be pregnant or have children. Assessment, support and accommodation services should take into account young people's relationships as well as any dependent children, and where appropriate, support to them to build a positive family life. So support and accommodation provided to a child in need can include taking account of their partner, can include taking account of their children if they have children. The guidance that this is taken from is the link is set out at the bottom. Provision of accommodation for 16 and 17-year-olds and who may be homeless and or require accommodation. Families with no recourse to public funds. Next topic, briefly. It is often the last resort for overstayers and for failed asylum seekers. It may be at the price of ultimately having to agree to travel back to a country of origin. Though there is a really helpful website, it's intended to be useful guidance for local authorities, but it does generally set out the law quite fairly in the guidance notes, and it's very useful to crib from at the nrpfnetwork.org.uk. You can sign up for expensive training with them, or you can just take the guidance for free, and I recommend taking the guidance. Two key cases which should really be on the slide. The first was Clue and Birmingham, 2010 decision. I'll go back to the previous slide, please, Liam, sorry. 2010 decision of the Court of Appeal confirmed that there was a duty to assist a family with a pending immigration application, where that immigration application had been completed. A case of MN and Hackney in 2013 confirmed that there is a duty to provide assistance to the extent it's necessary to prevent a breach of convention rights. And that includes not just the children, but also other family members who may be part of the same household. The next slide takes us on a bit further looking at that. The threshold to assess, if we look at the statutory guidance, working together to safeguard children, so assistance for families with no recourse to public funds is provided under section 17. Working together says 153, within 1 working day of a referral being received, the local authority children's services social care should acknowledge receipt to the referrer, a social work Qualified practice supervisor or manager should decide next steps and the type of response required, which will include determining whether the child requires immediate protection and urgent action is required, whether the child is in need and should be assessed under Section 17, if there's reasonable cause to suspect the child is suffering or likely to suffer significant harm, whether Section 47 inquiries are necessary, any immediate services required urgently by the child and family and what type of services, further specialist assessments, and so on. Now, it'll be borne in mind that under Section 17, the local authority can provide assistance in kind. It can also provide assistance by way of accommodation, and not only for the child, but for the family. So that is what the local authority has got a duty to assess. It's what the threshold is, and how quickly they should be acting. Next slide, please. A needs assessment. When it appears that there is a child in need in its area, the local authority must undertake an assessment under Section 17 of the Children Act. That's decided quite a long time ago in G. and Barnett by the House of Lords in 2003. The threshold for undertaking a child in need assessment is low and will usually be met when a family does not appear to have adequate accommodation or has insufficient income to meet the child's basic needs because of the parent's inability to access benefits or, in some cases, employment. When the threshold is met, a child in need assessment must be undertaken. There's a more recent decision, AM and Havering and Tower Hamlets in 2015. That is my contribution. If there are, at the moment there are no questions in the box, but do put them in if you want to. If you found our webinar helpful, there are others in the series. You can find them on our Chambers YouTube account going back over the years. You can also find, if you are appreciative and want to show thanks, if you look on our Chambers website for the Muzinkulu Trust, there's a preschool in South Africa that we've been funding as much as we can over the years. Contributions often from people who take part or join in our lectures, our webinars, our training. You're very welcome to contribute towards a preschool if you want to, but no pressure. No questions at the moment. Liam, is there anything that you wanted to add?
Nothing further from me, Jamie.
All right. Well, thank you very much, ladies and gentlemen, for your attendance this afternoon. We wish you a sunny afternoon before the rain comes, and we'll see you next time. And thank you.
Everyone, bye.
Good night.